Thanks very much. I'm Dan Rubenfeld, one of the NYU professors, and my goal is to try to wake you up instead of taking a nap. We'll try to give you a really lively session. I've got a great group of people representing four of the five BRICS countries. Unfortunately, our Indian guest speaker couldn't make it at the last minute because of a personal complication. But I'm pleased to introduce in the rough order in which people will initially speak. First, Alexey Ivanov, who is head of the Shkolkovo HSC Institute for Law and Development in Moscow. And he teaches, as I understand, a course in antitrust and the new economy for the Federal Anti-Monopoly Service in Moscow, and also practices law. And Alexey had several Russian degrees and also an LLM from Harvard. Next, after Alexey, is Christian Schmidt, who is a commissioner at CAGE in Brazil. And Christian also studied, got a degree in Brazil and also studied in the UK and at Columbia, that other universities. Can't remember where it is. But, and third is Xianlin Wang, who is Associate Dean of the Gokuan Law School in Shanghai, and it was an important advisor to the drafting of a drafting committee of China's anti-monopoly law, and has been also very involved in consulting for the WTO's Trade and Competition Policy Group. And finally, you all know Dennis Davis, because you met Dennis this morning. Among other things, he's a professor of law at Cape Town and has served in various roles on the Competition Appeal Court as a judge. And his training, I checked, goes back to South Africa and then Cambridge. So with that start, I've asked each of the four members of the panel to speak just relatively briefly about their activities in BRICS, and then following that, I will try to ask as many provocative questions as I can, and we'll see what we get for answers. So we're going to go a little bit out of order because I've asked Alexey to speak first because he has some new information about what's been going on with BRICS and some announcements to make. So Alexey, you've got the ball.
Thanks. Thanks a lot. I will try to be very brief, describing some of the efforts we're making in building BRICS together, closer, and what was actually talked about a couple of previous sessions. We do try to facilitate this cooperation with some of the extra efforts, because we do need to make an extra mile in the existing context, because yes, it's true that very much diversity in all the BRICS economies, within BRICS economies, and there is also a desire to be unique for each competition authority, but also there is a certain interest and definitely appetite for a closer cooperation. And what I'm going to say about is how we get there where we are now, and what is the kind of prospects for further cooperation. Back in 2015, when Russia was presiding in BRICS, you know that each year we have this BRICS summit where heads of the states are meeting together and discuss different issues, really broad spectrum of stuff covered normally, but sometimes they get something as a special topic for their meeting. And in the Russian presidency back in 2015, we decided to accelerate the conversation about competition domain, competition policy, competition law, and how this competition track could be built within BRICS. And that time it correlated to the research work we were doing with Professor Yanis Lianos, who was at a recent session as well, talking about mergers, and this was related to global food value chains. And global food value chains was in focus of our work, and we tried to reach out to a number of partners in the BRICS countries and kind of built a network of a community of academics, experts, as well as engaging with authorities to discuss deeper what's going on in the global food value chains. And it happened accidentally that those big mergers just started to pop up, and we didn't really expect this. I don't know what triggered this process, whether they wanted to just provide us some empirical data for this research, or I don't know, but it was not a conspiracy conspiracy between us, for sure. And we established a working group within BRICS framework, and basically it was the first kind of joint working groups of the BRICS authorities, including academics. And I think this working group did a great job, and basically we managed to deliver a report, and this report was kind of adopted by the authorities and heavily influenced the process of decision making, at least if I can say about Russia, that FAS, Russian authority, was massively using this results of this research work in the consideration of the Bayer-Monsanto merger. And the decision with Russian authority reached this year, basically last year, but preliminary decision was last year, and final decision this year on the Bayer-Monsanto merger was very much heavily based on the studies done by the working group. And it showed really a huge value of this type of cooperation, because we had an exchange process with all the authorities, primarily, as Tembi was mentioning, primarily in form of knowledge sharing. We were sharing approaches, we were sharing understanding how to deal with this type of things, and it was very efficient to a certain extent, because the Russian authority, and I will say about this a little bit later, when it started its work back in the 90s, when we kind of adopted competition laws after, centrally planned economy, it was adopted under those kind of presumptions which Professor Stiglitz earlier this morning was heavily criticizing in a non-critical way, because it was basically implementation through, uncritical recipients of those models which were developed through antitrust revolution in the West back in the 80s. So what we achieved through this cooperation with Global Food Value Chain Working Group is that authorities felt that it's very interesting to cooperate and to exchange information, to exchange approaches, to exchange methodological tools. And back in 2016, in May in St. Petersburg, the BRICS antitrust authorities signed the first memorandum of understanding, which included some mechanism of cooperation, of deeper cooperation, like liaison committee was established, and then it was decided that there would be more working groups. And this year, the major development is that the Russian authority decided that it would be important to further speed up the process and actually build up upon this initiative, which was primarily academically driven initiative for time being, and to institutionalize a kind of a support center, BRICS research policy, law and policy, competition law and policy center. And I have a privilege to be director of this center, which was established in Russia back in August this year. But it's a very inclusive and network-oriented kind of institution. So we want to engage with a number of academics based in BRICS. And here I'm now turning to the value of this type of cooperation, what kind of perception of BRICS competition agenda could be, and what it can lead us to. So the first point which I want to address is the topic on which Professor Stiglitz finished his presentation, is basically marketplace of ideas. He was saying that concentration in the market is leading us to basically extremely biased opinions on different topics, but I see one of the reasons it's happening is because of certain deep capture of knowledge production. We do understand that a lot of businesses, especially big tech, engaging a lot with academic communities, and basically through this, directing away development of our understanding of our theories, of our presumptions is going on. So one of the things which we want to change is to provide source of resources, of funding, of expertise, and the most important, of assurance, self-assurance for BRICS academics, so that they can develop alternative views, not being scared of, being marginalized in the global academic or knowledge production context. Because in the knowledge production of modern days, we do have dominant players, and most of those dominant players, unfortunately, they heavily rely on corporate funding and corporate resources of all different kinds. And so creating alternative source of assurance, of self-assurance, of support for BRICS academics and international academics who interested in developing of progressive opinion about antitrust and basically alternative views in the field is a hugely important thing. And this BRICS initiative or cooperation center can take a role in establishing this alternative source of resources. Another thing is basically developing those ideas which could be theoretically accepted much more broadly in the world, because there should be a certain kickstarting, supporting of this momentum, supporting kind of movement which would change change the way antitrust law and policy is developing. We see that there is such an opportunity within BRICS countries and broader in developing countries, which is now covered by the acronym BRICS Plus. And in some of the a number of summits of recent years, a lot of developing countries were participating. In the last BRICS summit, for instance, Turkey was very much present as a BRICS Plus member, and many other countries are interested, like Indonesia, Malaysia, and those who were historically part of the so-called non-aligned movement. And it's very important to say that this new kind of methodology, it should rely more on the interest of the BRICS countries, of the developing countries, and create alternative models in reacting to the major challenges of the new economy. And relating also to the presentation made by Professor Stiglitz early in the morning, I want to go to the Russian cases of a couple of recent years, which were to a certain extent encouraged by this visionary approach of alternative regulation on the global economy and digital economy. I'm referring to Google Android case, for instance, which was decided by the Russian authority back in 2015. And I do remember when first it was out, how much criticism was directed towards Russian authorities, saying like, you should not mess with big tech companies, you don't understand how this economy works, you don't understand all this difficult issues with algorithms, with open source data programs, and so on. And finally, we waited a little bit, and European Commission, to a certain extent, repeated the same approach. And basically, they don't refer to the Russian case, obviously, but they basically endorsed this position. So it's not any more marginalized position, which would be very easily criticized by mainstream academia and mainstream, I would say, bar, like attorneys, because, any authority needs certain brevity, to make decisions which are not mainstream, and stop, doing what, again, Professor Stiglitz was saying, like proving that water was wet, and just act, just do something, just react. So the decision we did back in 2015 against Google on Android, abuse of dominance in the Android on the Android platform, was one of those, very brave moves when you just react to the clear inefficiencies of the market. In Bayer Monsanto case, and I think I'm finishing, it was as well like a very unique kind of approach, I think, advocated by the Russian antitrust authority, because they were not focusing only on number of players in the market, because, as you know, it's a very tight oligopoly. And both DOJ and the European Commission, they decided the case in a very simple way. They were saying, like, just license out some of your products and divest some of the products, and they all went basically to another huge player, to BASF. And BASF is just, fourth largest company in the area, and also German company. So basically they have a lot of relations. They have the cross ownership. They have a lot of people even sitting like same kind of governing bodies. They're members of same associations and stuff. But it did suffice all concerns of the European Commission were kind of cleared with this kind of divestment. A Russian authority was thinking a little bit broader, saying like you do not solve problem of competition in this context when you have a very tight oligopoly. You have to enable other players, which are smaller players and which are not part of the club right now, which are not susceptible to the tacit collusion. It should provide ability for them to compete in the future, and that's why prescription and that's what I would refer to Professor Stiglitz' request for stronger remedies. So the prescription in Russian Bayer-Monsanto decision was to transfer technology to a broader number of players, so those players can be enabled to compete on the basis of technological capability, so that there would be a better dynamic, more active dynamic in the field, and also a number of access remedies which related to the digital platforms they're building. And here I'm finishing just to mention that all the developments in the global marketplace are showing that they should be really like kind of at least second vision, a different vision. I mean, at least a couple of different, ways of development of antitrust, because otherwise the price of mistake would be too high. And basically, if we all follow kind of one mainstream approach, so finally we can really end up nowhere. And what we see with the growing concentration and inequality, that's pretty much a symptom of this type of development. Thank you very much.
Thank you very much, Alexei. That was terrific. As we move along to the other members of the panel, I was going to ask each of you, as you're discussing your own country's situation, to let us know how you envision your country's role playing with this new competition arrangement that Alexei was just talking about. So we'll start with Christiane. We'll get the Brazilian perspective.
Thank you very much, Professor Eleanor, for the invitation, and Professor Rubenfeld to coordinating this panel. It is an honor to be here again for the second year, having the opportunity to share some of my experiences with such a great group of professionals. As a normal disclaimer I always make, I'm speaking as an independent commissioner, not on behalf of CADE. I think I am going to make it to take less than 3 minutes here in this brief approach to describe the involvement of Brazil as a country in BRICS concerning competition matters, mainly because the hot topics the country is negotiating with the BRICS member in a broader agenda. It's not regarded specifically with competition issues. The BRICS agenda as a whole in Brazil has been conducted by the Ministry of Trade and Industry, by the Ministry of Finance, and by the Ministry of Foreign Affairs, and not exactly by the Ministry of Justice or CADE, remembering that CADE is an autarky related to the Ministry of Justice. Marcelo Estevão, from the Ministry of Finance, is responsible responsible since the President Temer took place for designing the BRICS countries agenda, at least up to December 31st, when we are going to have the new president elected. And the new development bank is being the center of the discussion in my country. So on one hand, the bad news is that competition issues, unfortunately, are not being contemplated by the Brazilian macro agenda, and as far as I understand, will not be in the near future. This reason is because the new development bank has been the main concern in terms of macro negotiation, and now they are trying to launch the bank's operation in China, and which is the sole objective is to address how to finance sustainable infrastructure projects. Maybe when the new development bank is ready in place and doing whatever it's supposed to do, competition issue could come up, but realistically speaking, I don't think this will happen soon, because trade and investment issues should be the next topics before competition policy or any other subject. On the other hand, the good news is that in terms of competition matters only, CADE, that is the Brazilian antitrust agency, has been very active, making a huge effort to enhance the already existent cooperation agenda with the other 4 authorities. So far as I understand, besides interesting studies, as he said here, and relevant best practice discussions, The main factual advantage for all 5 countries regard information exchange concerning mergers and acquisition concrete cases, as Bayer Monsanto that he mentioned here, and international concrete cartel assessments. So those are my final remarks here.
Thank you, Christian. Our next speaker will be Sean Lin, telling us about the China perspective.
Good afternoon, everyone. I'm from Shanghai Jiao Tong University, China. I'm very pleased to be here to attend this conference and speak. Thank you very much for kind invitation. As anti-monopoly law aims to, as the largest and fast-growing emerging economy, the BRICS countries are somewhat similar in terms of economical development and the social conditions. The situation and then task as regard market competition and anti-monopoly faced by each of them are also similar, as are the background and main systems of their anti-monopoly laws. As anti-monopoly law aims to remove illegal monopoly and maintain free and fair competition, it is supposed to be based on market economy and corresponding competition mechanism. Some BRICS countries implement the market economy earlier than others, thus generating an earlier demand for anti-monopoly law. Others implemented a centrally planned economy in the early days, denying or even rejecting market competition, thus offering on basis for anti-monopoly laws. For the former, their anti-monopoly laws were developed and improved along with their government's deregulations and the implementations of economic reforms. For the latter, as they shifted towards market economy, the demand for anti-monopoly laws were gradually generated, and then the system of such laws was consistently improved as their market economy development. However, compared with the United States, which has a comparatively sound system of anti-monopoly law developed over more than 120 years, the BRICS countries either have a shorter history of anti-monopoly legislation or have begun to implement an effective system of anti-monopoly laws only in the recent 1 or 2 decades. Therefore, on the whole, the anti-monopoly systems in the BRIC countries are still in their initial stage of development. China is the last BRIC countries to establish the basic system of anti-monopoly laws. During the 30 years after the founding of New China in 1949, China has implemented a central planned economy, offering no economical foundation for any anti-monopoly law. However, the market-oriented economic reform beginning in the early 1980s generated the demand for combating monopoly and protecting competition through legislation. Therefore, a number of anti-monopoly laws and regulations were generally adopted, especially the anti-monopoly law of the People's Republic of China was approved on August 2007 and took effect on August 2008. As for the legislative purpose of police objectives of the anti-monopoly legislation in BRICS countries, there are both similarities and differences between the legislative purpose and the police objectives of the anti-monopoly laws in the BRICS countries. In terms of similarities, these laws and regulations are explicitly or implicitly aim to maintain free and fair competition so as to improve economic efficiency and safeguard consumer interests, although such objective is more expressly stipulated in the anti-monopoly laws in China. However, other objectives reflect specific differences among the historical backgrounds, economic systems, main tasks, and the international environments of the BRIC countries. In general, although the systems of anti-monopoly laws of the BRIC countries differ in specific institutional and policy objectives, they have similar historical backgrounds, rules, and objectives. In particular, anti-monopoly law and competition policies are used as important means to achieve the goals of economic development and have played an important role in implementation. The BRIC countries are relatively large emerging economy, although the development of their economy and anti-monopoly systems was relatively late. Recent years saw their rapid development. The 5 countries have more similarities in competition and anti-monopoly policies, which shall be considered as an important aspect in their cooperation. In this sense, it is of practical significance to determine a competition agenda by the BRIC countries. Thank you.
Thank you very much. Our last speaker at this round is Dennis Davis. Dennis, thank you.
Thank you very much, Dan. For 2 reasons, I suppose I'm the odd person out here. The first and most obvious is because I'm not the Competition Appeal Court, South Africa. We don't worry about these sort of trivial matters such as administration of how BRICS is going to work. We just wait for cases to come to us. The second reason is because Jim O'Neill, now of course Baron O'Neill, who was the man who coined the term BRIC at the time, which was excluded South Africa, has expressed the view subsequently that he can't really understand for the life of him why South Africa has been added to BRIC. So I really am the odd person out, and I'm going to therefore try, if I can, to just talk a little bit about why this is important for us. And I think this piggybacks off some of the conversations we've already had today. If you look at the various countries, not just BRICS, but those aligned to that, all of them in their competition laws have, as it were, something beyond the traditional. So if you look at South Africa, as I've already indicated to you in the bill, but it really reinforces our Act of 1998, the idea of competition law was in part to redress the balance of what had occurred under the apartheid era. The famous story is told that we weren't really going to have a Competition Act. Mr. Mandela came out of prison and he went to Davos a year later. And he was asked, what is the economic policy of South Africa? And he said the economic policy of South Africa essentially is the nationalization of key industries. And of course, all of these industrialists and business people at Davos spluttered over their Lagavulin or any other single malt whiskey that they drink there. Since I've never been there, I haven't idea what it is that they drink, and said, you know, that's not a good idea. And he came back to South Africa, and since I was actually at that meeting, I know, and he said, we got to think of something else. And competition law was spawned out of that particular moment, a revamped one. And if you look at the South African Act, it talks about redressing the disadvantages of the past, the skewed ownership, which was racially constructed, etc. And so it's not surprising that the South African Act, therefore, has public interest and, if you wish, at least a nascent normative framework which points beyond cognizable traditional competition concerns. Well, we're not the only country. I mean, many others, Botswana and Cameroon, talk about citizen empowerment. The Chinese anti-monopoly law talks about the promoting of the healthy development of the socialist market economy. Well, that may be a bit of an oxymoron, but the fact of the matter is that it's there. And the Indian Authority talk about the contribution that competition law can make to economic development. And so what I'm trying to develop here is, like it or like it not, these countries essentially have formulated competition legislation which, as it were, is somewhat different from the competition law developed in Western countries in general and the United States in particular. And so the real challenge for all of us is to ask the question as to what level of competition law would be needed for the stage of development of these countries. And can we really confidently say that one size fits all? Well, I really find that a difficult hurdle to jump over because it seems to me that the answer's already been given. These countries don't think that the same level of competition policy is good enough for them. They want something slightly different. And so the real challenge here is, how do we develop a more coherent framework which is a response to these countries' needs in circumstances where traditionally competition law has nodded in favor, firstly, of the United States, which grandfathered the whole operation, and later the EU. And most of us who teach competition law, including myself, and I have to pay mea culpa for that, we sort of start off and we talk about the US law, and we talk about the EU law, and then we sort of muddle along and say, actually, there's something called like EU plus, and that's where we sit. But God knows what that means. And as a judge, I have to tell you, as much as I've attacked our constitutional court in many writings about their absence of a normative framework, I must concede, as the head of the Competition Appeal Court of South Africa, I'm not sure we've developed a proper normative framework which would guide us to vindicate, as it were, the promises of our Competition Act. Now, it's interesting, in 2013, the then Indian Prime Minister, Singh, at the BRICS Competition Network, the BRICS Conference, in 2013, spoke about that the competition law enforcement regime could not operate in isolation. Competition policy had to be shaped and transformed by existing socio-economic policy, suggested, quote, that the BRICS countries can entertain many possibilities of newer forms of economic and political coordination. We also face common challenges. 2 years later, the South African Minister of Economic Development is responsible for competition law in South Africa, Mr. Patel, at the 4th BRICS competition conference in Durban, said, increasingly, citizens require their governments to show how policy promotes human development goals. Competition law, too, is under scrutiny. Not only should it tackle entrenched economic power and provide opportunity for new entrants, it must also clearly, not just implicitly, demonstrate benefits for a state's industrial and consumer objectives. So you can see, just from these two citations, that there was a desire in BRICS to develop what I suppose sociologists would call a counter-hegemonic project. That is, an attempt to develop a competition narrative which was different to that which had been borrowed almost uncritically from the US and the EU. And that's a massive challenge. So it's all very well that we've had debates today led by Professor Stiglitz to start with, which are enormously interesting. But think about it, not so much from an intellectual endeavor now, but from the point of view of the practicalities of developing competition law in circumstances where is your precedent? Now, I know economists can be original. I've experienced that enough times under evidence where they've got about 43 theories if you don't like one. But we lawyers are a boring bunch. We, in a sense, have to use precedent. And the question is, what precedent do we have to give content to these very ambitious objectives? So let me give a practical example of why BRICS can help. I'm sure this is true of other countries in the developing world, but it's certainly true of mine, that the large international economic firms, these private firms, have made a really good killing in South Africa. They sort of roll up and they give evidence before the competition tribunal at great cost, which is why the rand always depreciates when they leave. And they, in a sense, then advise the tribunal on behalf of defendants from a perspective which is very much divorced from all of these objectives. Because they're looking at things from the US or the EU, and there's a kind of conflation that what is in the US or the EU must be right and everything else must be wrong. So we talk about antitrust sort of insiders and outliers, which is a somewhat of insulting term to those people who, in a sense, are grappling with these demands from a slightly different perspective. Now, as a judge, listening, I don't, thank goodness, listen to the evidence. I just read the records on appeal, which is boring enough. But the point about it is that one needs some guidance as to how to actually give content to these ambitions. And so why is this all relevant to BRICS? Because it seems to me that there's a real possibility here for the BRICS countries to be able, together with other developing countries, to sort of put some flesh onto the skeletal framework of the objectives that I've outlined. They're not all the same, but they sure as hell are different to that which pertains in the US and to a large extent in the EU. And that is hugely of assistance in developing a coherent jurisprudence. Because to come back to a point with which I agreed with all my panelists, our fellow panelists in our session, earlier session, I am prepared to absolutely concede that certainty and clarity and some understandability of jurisprudence is absolutely essential. You're not going to get that from politicians, but you may be able to get that from courts properly advised by proper rigorous research, which has tried to actually grapple with all of these challenges. And so the real advantage for BRICS is, in a sense, to become a laboratory for an alternative vision which is there in the writing of all these pieces of legislation. But there's a huge gap between the aspirational content of the legislation and that which actually pertains in practice. And that's the real challenge, Dan, for the BRICS countries in general and certainly for my country in particular.
Thanks, Dennis. You've actually teed up the next question, but before I ask that question, I feel like I have to defend the economists, the few of us in the audience today. So I've been, as I think you and I have discussed in the past, Dennis, I've been to South Africa many, many, many times because I was involved in the World Bank project there starting in around 1995. And when I first went to South Africa working with the ANC, I had all these economic principles that I've been taught and been teaching my students. And I can tell you by the time we finished that project, about 4 or 5 years later, I had followed none of the principles that I was taught because I had learned about the institutions that were particular to South Africa. So at least a few of us have been chastened by
I
that.
appreciate that.
So my question really follows what Dennis said, and that is I want to ask each of the panel members, I guess the other three to start with, whether they have any thoughts as to where BRICS might go beyond where it is now in terms of finding areas of joint coordination, maybe new projects in particular sectors, areas where BRICS might further develop the answer to the question Dennis asked about what should be the BRICS specific competition, a set of goals and principles. So I'll just take them in order. Anyone want to speak up? Christian, you want to? Or I guess, Alexa, you were first, so I'll give you the first shot. Either one.
Or maybe Chris first.
Okay.
Christian.
Well, my views are that although BRICS share common views supporting greater cooperation, they are very diverse politically, socially, and economically speaking. So maybe I disagree a little bit that you said that we have similar historical background. I don't feel like this, but anyway, and those differences may reflect on having major differences regarding legal and institutional frameworks on a lot of subjects, including competition policy. These differences, therefore, make it very complex to address a unique competition policy as a cohesive tool for the bloc. However, a competition cooperation agenda, not a competition policy agenda, but a cooperation agenda is what is possible to be done, and it's actually what BRICS competition authorities, not the government level, but competition authorities are doing. So I can give you three very recent examples to reinforce this point. Yesterday in Brazil at IBRAC's meeting, that it's a kind of ABA meeting, the BRICS members signed a commitment that they will start studying on a study on digital markets to understand how countries are defining relevant markets, market power, and so on. The other example that I can give, in 2017, BRICS signed a memorandum of understanding also to exchange of information and sharing best practice and capacity building activities. And also in 2017, we signed 4 bilateral agreements, two with China, 1 with India, and 1 with Russia. Not with South Africa, I don't know why. I'm sorry. And besides that, I could point out 3 ways in which cooperation is taking place. One, that is, I've already said, that it's the most important, information exchange in concrete cases, that it's helping CAGI a lot, I can say. So I can mention Bayer-Monsanto case and Siemens-Alstom International Cartel also. Also, in terms of working groups, and I can mention the digital economy, I think is the principal one. And it's the one that Brazil have a lot of issues, a lot of doubts. So I know that we have another groups of studying at automobile industry and global value food chain. But those markets, I don't know if Brazil have this really need to understand, but the digital market, the digital economy, this new area of information for sure. And in terms of participation in forums, I think we are doing great as well. We are trying to share some experiences. Last year we did a one in digital markets and trying to understand how cartels are being done nowadays. And in the near future, in 2019, we are going to have the BRICS meeting. And we are going to be talking these digital markets again.
Thank you. Alexei?
Yeah, I would say that we actually have a very clear agenda. I think we can agree that BRICS countries are quite different, but any countries are different, basically, and developed world is very diverse, and it doesn't create any problems to cooperate closer, you know. European competition network works pretty well, like US and EU coordinate a lot of efforts. EU signed agreement with Switzerland, which is very deep in forms of cooperation. Like, I mean, all sort of cooperative frameworks with quite different countries are possible. But what breaks, I think, sharing as big but a little bit big economies which are still a little bit outsiders. And that's kind of a shared sentiment. Why so? Because, all of those countries, they had a little bit different track of development, which was at a certain point, didn't become mainstream. So neither even like China, which is like biggest player within BRICS, no India, no Russia, do have a say in the global affairs, which kind of correlate to the both size of the economy and ambitions. And they, for a number of years, were rule takers rather than rule makers, and their interest in influencing like global affairs, especially like in all sort of international organizations which are existing now, is not at the level they would like to it would be. So when we're lacking the global governance of antitrust, there is no like global governance for competition laws, although there is a global system of protection of IP rights, which I think is a little bit less logical than having same system for protection of competition, because IP rights should be more like national related choice, and competition, it does have an impact on the global economy, and it's, I think, more need for globalization of the governance regime, of legal regime for competition. But lacking this, we naturally create a kind of demand for some sort of substitutive mechanism, substitution. And this regional cooperation, BRICS type of cooperation, BRICS Plus type of cooperation, is basically providing this kind of second best solution for global governance of the global competition. And I think the way it's evolving now, BRICS cooperation, is pretty much clear. Chris mentioned those working groups, and those working groups established, they are really working. So the food working group delivered, digital working group is in process. We anticipate the next, this biennial international BRICS conference, which happened last time in Brazil, last year, before in South Africa, in India, in China, and the first one happened back in 2009 in Russia. And so the next one is going to be hosted in Russia. It's already kind of anniversary because the cycle is repeating. So we're very committed to make this forum, this biennial BRICS Competition Law and Policy Conference, not just a ritualistic conference, but more like a decision-making format, where we will deliver this comprehensive report on digital markets with leadership of Brazil, but with a very active participation of academic community, and that's what we try to facilitate. And again, Yanis Lianas is here, who very actively devoting his energy to this work and leading this work academically within this context. With this network we established through this BRICS Anti-Monopoly Center, and we want at the BRICS conference next year there would be comprehensive new, I would say, even set of methodological approaches which would be of kind of alternative kind, and which could be used and endorsed later on by all sorts of authorities around the world, including major ones of developed countries, like it happened with Android case. They basically didn't mention that they relied on Russian experience in dealing with abuse in this platform, but they did it, basically. They did use this experience pretty much in copycat style. So there are many of the challenges in the global trade which are not addressed by the developed world because of many reasons. And a couple of sessions ago, it was like a session on industrial policy. I just want to say that in industrial policy debate, it's usually considered as an instrument of empowering authorities to consider kind of different elements of the conduct or in merger review. But in Russian, for instance, context, industrial policy was massively used as a defense. So because, for instance, there is industrial policy to promote innovation, and we see it in many other countries, and companies, big tech companies, saying, don't stifle innovation and don't mess with us. Although promoting innovation is an industrial policy. there is no like a dogma that innovation should be promoted. People could be even better off in some areas when it's less innovation, actually, because of, I mean, in digital context, it's very clear. Sometimes, like social well-being could be better preserved without like some new developments, or those developments should be more sustainable, more like inclusive rather than they are. So in this continuing this, I would say that this would be the first deliverable, this comprehensive report on digital markets. It would be presented at the conference, biannual conference in 2019 in Russia. Russia presiding in BRICS again back into 2020. It would be a BRICS summit in Russia after the conference. So September 2019, this conference, May 2020 BRICS summit in Russia, and we really hope that BRICS leaders would consider further steps in institutionalizing this cooperation, maybe establishing intergovernmental organization OECD style.
Thank you very much. By the way, if you're thinking of inviting me to your next meeting, I should alert you that the last time I was invited to Russia, I arrived at the time that the attempted coup and the barriers were going up. So there may be some causal link there, so you might want to think twice. But on a more serious note, Shanlin, do you want to add some comments about where you think BRICS is and where it's heading?
Yeah. Although I think it makes sense for BRICS countries to determine a common agenda for competition, the scope is limited, at least at the present. Taking into account the situations of international competition policies at present and in the foreseeable future, and the fact that the conditions in the 5 countries are still quite different, the scope of the competition agenda should not be too broad, but should be mainly focused on mutual coordination and law enforcement cooperation, including different levels of bilateral and multilateral coordination and cooperation. The BRICS agenda should include the interaction and coordination between trade and competition. This is because there is a close relationship between trade and competition. Now that the 5 countries want to strengthen economic and trade cooperation, they must cooperate in competition policy. At least they should not allow competition to become an obstacle to their mutual trade development. There are many issues to be discussed in the BRICS countries in recent years. In terms of competition and anti-monopoly policies, it is a priority for competition enforcement agencies in the BRICS countries to strengthen mutual coordination and cooperation. In addition, there are cutting-edge issues involving anti-monopoly as well as big data and intellectual property, and that can also be discussed. Thank you.
Thanks very much. My next question was going to be kind of what are your thoughts about new ideas for the next meeting in Russia? But and you've mostly answered this, but let me just see whether anyone on the panel has anything to
Can I
want to
just
add.
make a comment?
Sure, go ahead.
I just want to make a comment that I'm not arguing for uniformity. I think there's a very big difference between convergence in the literature and diffusion. Right? So what I'm talking about is in a sense of a diffusion of ideas which are alternative to that, I mean, to convergence, which very often means convergence towards the US model in the traditional thing. So I was looking for something I'm talking about something very different to
So
the idea
something
of
like a common framework, but then
Well,
adapts different
I think you're
applications?
going to get different approaches in the various countries, Dan, because I think they all are at different trajectories and they have different indigenous demands. But there are commonalities. There is, I suppose, a Rawlsian overlapping consensus, but on the other hand, there'll be differences. But the fact that you then get a whole diffuse range of alternatives which start to emerge, and a pool of experts and expertise and studies which can be shared, just makes life so much more easy for these countries to, in a sense, vindicate the promises of their legislation. I certainly don't think that what I'm certainly arguing for is that everybody then just will have a BRICS model which will be opposed to an American model. I don't think that is at all the position. So if that was what I was suggesting, I just want to clarify that.
Thank you.
Okay.
Christiane, do you want to say
No,
something?
just make a comment, because what I think is very hard and very complex is to make a common competition policy agenda among everybody.
I agree.
And because, like China just said here, that trading competition should be together. This will come up with trading competition.
Yeah, go ahead.
I can just say that in Brazil, maybe it's not going to work, but in South Africa, maybe it works. So we are so different. Our backgrounds, I think it's so different that to try to bring up like a common competition agenda, policy agenda, a policy, it's too hard. So if we continue to cooperating with each other, and I was very glad to learn today that how important BRICS was for South Africa. I don't know exactly if it's the same for Brazil, but of course, to be around with developing countries are also very good. But then come up with the question, why we don't do bilateral negotiations? So that's the main question here, because when we are together, like South Korea or Turkey, Mexico should be there. I don't know exactly. So maybe we are going to talk about this, but so this is what I'm talking about. It's a common competition policy, not common cooperation policy. Different things, yes.
Yeah, yes, I accept that. All I'm suggesting is that the danger is that you have a common competition policy, and it's called the US model, or the set of variations. And what you're trying to develop here, countries are very different, but there are similarities because of development, which in a sense means they can talk to each other in a manner which is very different to the developed world.
No, I understand.
And that
I
then
agree.
diffuses
This is
knowledge
where I agree.
through them,
Yeah.
which I think at present they've been impoverished in relation to. That's the only point I want to make.
So I wonder whether there are any lessons for any of the BRICS countries from experience of some of the other OECD members like Korea or Mexico or perhaps Turkey that might give you some advice, because they're OECD members, and Frederick may have a different view about this, but they may have some lessons that would be insightful for BRICS. Is anything, in fact, if you're being really aggressive and you want to keep Frederick awake, you could talk about going out and incorporating them into BRICS and getting to secede from OECD.
I would certainly never advocate keeping Frederick
I'm just
away.
joking, Frederick. I just wanted to see whether you would smile, and I've achieved my goal. But on the serious point, are there lessons, a more serious point, are there lessons to learn from some of those countries? Any of you, I'll take them
from
in
my
order.
position, certainly. I think there's no question about that. And I think, in a sense, the point about BRICS is it's, in a sense, has an organizational heft, perhaps a potential for. But beyond that, it would be quite silly, it seems to me, not to lift one's gaze to the broader perspective where these countries that you've been mentioning, many of them, have lessons which they can teach us, and this sort of dialectical relationship where we could have a dialogue with them too. I think that's absolutely right. And some of them are perhaps, South Korea certainly, I find some of the developments there actually of some considerable interest to me.
Thank you. Alexei, go ahead.
Yeah, may I just comment on this? I don't think that this BRICS initiative is kind of contradicting existing fora. I mean, like OECD is a great place, and it did a lot of work on advancing competition laws, and I don't think that there is any kind of internal contradiction, being in both places. And I know Brazil is now very actively trying to get in to OECD. Russia was actually in the process of joining OECD, and I think if the political crisis wouldn't happen back in 2014, I think we would be there technically, because the process was very active, and I know that the Russian authority is kind of observing, participating in competition commission committee very actively, and so it doesn't mean that it should be like kind of two blocks. It's not like Cold War and competition law. It's a totally different modality, I would say. It's a more inclusive project, and I definitely agree that other countries should be in one way or another. Turkey is already very active, and for instance, in Sochi last month, we had a meeting of BRICS liaison committee, but as well, there was head of competition authority from Turkey, from Indonesia, from Pakistan, from Nigeria, Mongolia, a number of countries, and they were all very actively involved, and they wanted to play a role. So that's what we're saying, BRICS Plus. So why BRICS? Because it just happened. It's happened probably accidentally, as Dennis was mentioning. I mean, but people liked it. This format existed, and so it's a center for crystallization. When you in a kind of elixir, I don't know, put something firm, and so crystallization starting. So BRICS, just analogy of this type of clusterization agent. Yeah.
Thanks. Qianlin,
Yeah,
do you want
just to add, because
go
I
ahead.
agree with both of them.
Yeah, go ahead.
I think it's just a different kind of interaction. I think with OECD members, or to go there to the meetings, are wonderful, because we see the benchmarks, we see examples, we look at to try to see if it works in our jurisdiction. But to be with developing countries, it's another kind of interaction. It's exchanging interaction. It's like I can explain you how I do it, and you explain how you do it, and I think we learn a lot from that.
Yeah, that's.
Thank you. Qianlin, did you want to
Yeah.
comment?
Yeah, I think this is a political rather than a legal issue. As far as the name and the meaning of the word BRICS is concerned, it is appropriate to maintain the cooperation among the current 5 countries. But considering existing cooperation forms among other countries with similar situations, membership expansion can also be discussed. However, if these countries are allowed to join the BRICS, it is like dividing the current G20 into 2 campuses, the developed one and the developing one. Thank you.
Thank you very much. Well, I actually have a bunch more questions, but I thought this might be a good time to see whether some of you in the audience who are still with us have any questions to ask. If you do, raise your hand and just let us know who you are. Or maybe you want to hear more of my questions. Anyone else? All right, go ahead, sir.
Yes, my name is Bill Rapp. I'm a professor at the New Jersey Institute of Technology. I sort of raised with our South African representative earlier, but he didn't take advantage of it. But one of the things that I see missing here is the whole issue of standards, intellectual property, which tend to be a major focus of problems that arise when particularly US or EU talk about industrial policies in other countries. When I was a commercial counselor in Japan during the 1980s, this was a significant issue for us, standards and intellectual property as a way of basically implementing industrial policy and keeping, promoting local champions and keeping foreigners out. So I'm just wondering to what extent this is a problem with the BRICS, or that with the BRICS relationships to other countries. Certainly it's been raised, issues have been raised recently in this regard with respect to China and as well as India. So I'm just curious. So this is
Thanks.
something that seems to have been avoided, but maybe we're planning on it later on in this session, but I think, this is a big elephant in the room. Standards and intellectual property, the use of standards and intellectual property rights as a way of promoting industrial policy, and particularly vis-a-vis large multinational enterprises.
Thank you very much. Let me give everyone a chance, and unless you want to comment on that question, Yannis. Yeah, go ahead. Yannis has been very involved in the BRICS operations, as many of you know, so he's in good position to
Yes,
tell us
so
about
with
it.
regards to what you mentioned before about standard essential patents, I think actually it's a very important debate. And also it's something that will be discussed in the context of the digital markets, because one of the things that we've been focusing on is Internet of Things, and the development of, with regards to Internet of Things. And obviously, there are issues concerning standard essential patents there. But I want also to mention that, because we discussed before about industrial policy and competition law, the way actually the jurisprudence of the various countries has evolved with regards to the question of standard essential patents, very much also dependent, I have to say, that's my observation, about, and if they're pro-implementers or pro-innovators, I'll call it that way, it very much depended also on their position in the value chain, right? And for instance, one might say that China has probably been, which was much more pro-implementers at the beginning, and has somehow moved towards an approach that is more, innovators-friendly. And obviously other countries as well, even, in the EU, we see, for instance, the recent judgment in our Unwired Planet case by the Court of Appeal a few days ago, which some have somehow analyzed as a form of Brexit competition law, in the sense that it's much more pro-innovator than pro-implementer. Basically, I think it interprets quite narrowly the GTE case of the Court of Justice, and might have been influenced by the fact that we might want to attract quite a lot of this adjudication in London. So I think the relation with industrial policy and competition law is a much more complex one than just basically, thinking about industrial policy in terms of promoting national champions versus, the competition law. I think you might actually have industrial policy influences in also quite complex competition law IP interaction questions. And certainly this is something that we will study in this group with regards to the Internet of Things in particular. Yeah.
Thank you, Yannis. Anyone on the panel want to comment or extend that? Alexei, why don't you go first?
Yeah, I just mentioned that this example of treating IP within competition domain is very kind of characteristic or symptomatic within Russian context, because when we first kind of implemented competition laws into our legal system, we were in process of negotiating to access WTO. And in 2006, we signed this bilateral agreement with US on, accession process. So US basically agreed to accept Russia to WTO. And one of the points within this agreement was that we have to provide immunities, like exemptions for IP rights within competition law domain. So the US trade representatives basically were pushing for this type of solution in our national laws. And it was done. Actually, 2006, when this bilateral agreement was signed, we put those kind of exemptions to the Russian competition law. And actually, those exemptions were pretty much justified by this type of reverse kind of industrial policy argument, because that was said that don't mess with innovation, don't touch IP because it's not your business. Focus on, something else more basic stuff. And Russian authority and Russian government basically accepted this. And that's how this convergence sometimes has very particular phase, you know? It's not just accepting the model, but accepting in a way it was specially like export variation, you know? So it's packaged in a way that it will be fitting interest of those who packaged it. So it's a kind of way how you include competition law proliferation in your trade negotiations, which relate to your industrial policy and your national interests. And now we're trying to get rid of those exemptions. And very interestingly, that because number of generation of lawyers and economists was growing with those like exemptions in the law, they think that it's normal. It's like, you know, you're living under pressure for years, and then you can't just, you know, live without it. It's I don't know, Stockholm syndrome or whatever. So just to create alternative vision that it could be different, so we have to make like double efforts, and that's where BRICS cooperation and kind of new mainstream for developing world would be established and very helpful. So thank you for this point.
Thank you. Dennis, go ahead.
Yeah, the reason, thank you for reminding me again, I'm going completely senile, and I'd forgotten that I promised you I would raise it. It's an exquisitely difficult issue because of the fact that in developing countries in particular, they warn that if they don't have a rigorous IP system, and that's why you've got your exemptions, well, you'll lose all sorts of access to all the goodies of intellectual property that's generated in the developed world. And there's a really interesting literature about whether, in fact, what promotes development in this regard. One thing I think we can accept is that many developing countries are starved of access to all sorts of the fruits of intellectual property. And that becomes a really problematic issue. Talk about a sort of two-sided market. Here is a classic example thereof. And it plays out both in relation to competition on intellectual property, and by the way, it plays out in taxation. Because one of the great ways in which money is stripped out of developing countries, and I say this as the chairperson of our National Tax Commission, is through royalties which are sourced in intellectual property. So this is a major issue. I'm certainly not going to give you an answer in 2 minutes. What I am going to say, it's the sort of question that seems to me is crying out for precisely the kind of agenda of looking at this in a manner, and that is where there can be some broader consensus, because if the various countries represented here can start thinking through this rather more fully, then in a sense, the kind of binary between total protection for IP and with some wishy-washy TRIPS exemptions and or nothing, and no access to anything, that becomes really important. And I'm afraid, unless developing countries have access to technology, they're in serious trouble. And so that's why it does become central to this agenda.
Just to make a
Christiane?
comment.
Yes, please.
That this is a major issue for sure, and I totally agree. But it's just to point out that our laws are so different. In our law, the Brazilian law, we don't have IP there. We don't have this issue there. So we just focus on anti-competitive practices. We don't have also public interest that I think South America has, Russia has, and China has. Brazil does. Brazil took it off. In the new law, we decided to take it off. And why we did that? Because first of all, it was bringing too much insecure, because maybe the antitrust agency could use this interest, public interest, in a general way, how the antitrust agency would use this. So it's so broad, it's so you can use it in so many ways that we decided to take it off from our law. So our law, it's very, very focused. And the thing is, competition for us, it's a way to get productivity. It's a way to get development. It's not the final thing. It's not competition policies should be like a way to be more productive. So for us, We need development. And cartels and anti-competitive practices try to put down this development. So let's put the agency to try to get rid of this cartel and anti-competitive practice. So we are very focused. We are not broad as my colleagues. I think the laws of my colleagues here are. So IP. Coming back to the question, IP is extremely important, and there is an involvement with competition, but it's not in our law. So it's not in our jurisdiction, in CADE's jurisdiction.
Thank you very much. I just have one comment from the perspective of an economist again. I spend a lot of time thinking about innovation issues. This goes way beyond standard essential patents. But to me, innovation is a very broad concept, and it covers not just sort of raw, basic R&D, but it also, one can be innovative in applying ideas in new areas, in really finding ways to diffuse new technologies, in finding more clever distribution systems. And if you think of innovation as broadly as I've described it, the implementers of IP can actually be innovators themselves. Yes. And so the initial distinction we make, which I think is pretty standard, it's one I make as well, between implementation and innovation, really is a little bit too simple to characterize the problem. So there is a role, it seems to me, for countries like the BRICS countries who can actually think of themselves as innovators, but in a somewhat different way. No one is yelling at me, so that's a good sign. So one other question I had was, let me assess one other question first. I think it was, Christiane, you talked about the New Development Bank as a fairly new endeavor in BRICS, and I'm curious how, if at all, that will influence the role of competition in BRICS. Does anyone tell us about it? Okay. Yeah, go ahead.
So the New Development Bank was set up having the core purpose to mobilize resources from BRICS members to finance sustainable infrastructure projects in BRICS, and maybe in other developing countries. But it doesn't talk about competition. So when you say about competition issues, it's not a part of this broader agenda. It's in our agenda. It's the antitrust authorities' agenda, but it's not in this broader agenda. And also the contingent reserve arrangement that is also there. Again, it's the purpose is to relate to respond short-term balance of payment pressures. It's nothing related with competition policy as well.
Anyone else want to comment?
Can you just mention that New Development Bank was a successful example of potential institutional cooperation within BRICS, and so they managed to establish something. So BRICS countries were meeting for years, just discussing stuff, and then one day they decided, okay, let's do something substantial, and they did, and achieved the result. I mean, it's early to say whether New Development Bank would change anything in terms of economic development in those countries, but it's clear that bank was established. So it means that cooperation could be expanded to other areas, and that kind of brings hope that theoretically in competition domain, one day those conversations would also turn into actions. I mean, more actions in terms of we already have actions, but more solid actions.
Thank you. Xianlin?
Yeah. Because of the status and the rules of competition policies and anti-monopoly in economic development, and the interaction between the trade and the competition, the BRICS cooperation institutions, including the New Development Bank, will certainly influence the competition policies of the BRICS countries to some extent. However, each country's competition policies and the legal systems are still mainly determined by their basic national conditions.
Thank you. Another question from the audience.
Yes, my name is Anne Tersinet. I'm a professor of law in a business school, in a French business school, EM Lyon. My question was to come back on intellectual property rights and competition law. Because, so I've got a question for Mr. Wang Xianlin. Because to my knowledge, there is a lot of research which is done at the academic level, for example, between Jiangning University and its Institute on Competition Law and IPR, and South Korean University. And I read that there is that the Chinese government launched a new project with Stanford University concerning digital justice on this question of the links between intellectual property rights on one hand and competition law on the other end. And it's coming on this project of developing digital justice in China, which shows that those links between competition law on one hand, competition policy, and IPR is really a key issue for the Chinese government and is taken into account. So can you say a few words probably on the stage at which this project is?
Thank you for your question. I try to brief answer, but since I'm a member of the Anti-Monopoly Commission, the expert groups, so as long as if it is concerned to a case, especially in China, I cannot understand. I'm sorry.
I appreciate your caution. I think we got time. Did anyone else want to say something? We got time for at least one more question. Yeah, I see a hand up here. As long as it's not about IP in China, but it may be.
Sorry, but yeah. I may provide information for you. After several years drafting the guidelines on abuse of intellectual property will be published very soon. In China. Although in 2015 there is a similar regulation published by the SEC.
Thank you. I think we have time for one more question. Go ahead and tell us who you are, please.
My name's Helen. I'm from PUNET. So my question is more about the politics here. So we talk a lot about convergence of antitrust law globally, but then if we if we want BRIC countries to provide alternative model, and will that lead to a different direction, like the divergence of the global antitrust law? And also there are politics in between BRICS countries as well. I know, like for example, in trade. Industrial policies are also used as like retaliation as well. And there's internal politics between BRICS countries. How do you resolve such differences when you're trying to have a uniformed antitrust law? Thanks.
Well, sorry, if I could just say, I've been at pains to suggest there shouldn't be a uniform law. There's not going to be one, because I take the point that they're different, and you've eloquently pointed that out, so I agree with you. The question is whether, as a result, and I mean it's not just BRICS, but a broader thing beyond BRICS, BRICS Plus, as Alexei suggests, that what you can get is a sort of diffuse range of ideas being put out there, some of which may have commonality, some of which won't, but which speak to a different agenda to the one which predominates at the moment. Because as I've tried to indicate, convergence, in my mind, seems to be convergence to a US model, or US plus a little bit of EU thrown in for, as it were, just for flavor, and not much more. And the real question is, can we get a sort of broader, heterogeneous range of ideas on the table, which at least allows various countries to plot a path which doesn't inevitably lead in one uniform direction, which would be to the hegemonic position which has prevailed up to now. And if you listen to many of these conferences, it always amazes me that the position is taken, and we heard it earlier, that there's industrial policy and there's competition law, and competition law means X, and if you do anything outside of X, firms won't come, and you won't get investment, and you won't get intellectual property access, etc. Now, it does seem to me, therefore, that what one is really not talking about is a uniform global policy. That's not going to happen. And it certainly won't happen for all the reasons you mentioned and others. But what can happen is a sort of broader heterogeneity of ideas which percolates through and which, in a sense, gives more nuance to a developing agenda of developing countries at different stages of development, different stages of politics. But in a sense, it does, therefore, allow for different perspectives. Speaking for myself, I find it extremely difficult often to conceptualize how to marry some of the challenges that we have. So let me just give you one final example. And it was interesting, I had a discussion with Joseph Stiglitz about this once we were all finished with the Walmart case, which is, how do I weigh these things up? How do I weigh up the benefit to consumers of lower prices on the one hand, in a poor country? And I kept on obsessing in South Africa about the example I kept on putting to council, which was assuming that you've got poor people who have to buy a white shirt for their children for school. And the white shirt cost 20 Rand, as it were, before Walmart came in, and Walmart sells it at 15. Now, that's a massive advantage. But then if you wipe out all of these local producers, what then happens? How do we deal with these questions? And all I'm trying to suggest is answers to those are not necessarily forthcoming, certainly from the available knowledge. I'm not suggesting for one moment that there is a silver bullet to that, but it would be extraordinarily helpful as a judge trying to grapple with those questions to know that other authorities in some analogous set of cases have grappled with them in a way which allows me then to weld their knowledge to my own indigenous position. And at present, one really does feel like Captain Scott, and the Antarctic, where there's going to be nobody coming to save you. And that's really what I'm talking about, not a uniform law and not convergence. I hope that sort of makes it clear.
Thank you. Alexei, go ahead.
Yeah, I just want to say a couple of words on this. Actually, first of all, I don't think that heterogeneity of opinions and approaches in the competition law is a problem. I don't think. Even more, if we take as a let's say solution to solve current issues with global economy, what Professor Stiglitz suggested. To rethink or question existing presumptions. It's much more easier to question presumptions from kind of alternative angle and from an alternative institutional framework. It's much more difficult to do it within the system which established those presumptions, because it there is a sort of reproduction of hierarchy, reproduction of same mindset, and it's much more difficult sitting within European Commission Department, General Directorate on Competition, and thinking out of the box. You will probably lose your job relatively soon. And then, you're more interested in job security than promoting alternative agenda. So you do need institutional framework to support this process of questioning presumptions. And questioning presumptions is extremely important for proper dealing with global competition problems. Yes, you mentioned rightly that BRICS countries are not basically like give me example of solid union. I don't really know like really solid unions. NAFTA doesn't really work like solid, coherent. Even EU is very much in problem and very diverse countries there. But it doesn't preclude us to think more about global affairs. And for BRICS countries competition law initiative, they could be, without like messing with internal issues and trying to, unify everything, to have a different perspective on what's going on in the world. For instance, just today it was published like in one of the business newspapers that 4 major commodity traders, Cargill, Dreyfus, Bunge, and ADM, that agreed, these 4 companies, they control like up to 90% of commodity trades in wheat, for instance, important commodity. And they agreed to establish single like standard and platform for digital platform for commodity trade, which is a huge thing for basically future of the commodity trade in the area, which has a lot of implications for vertical competition, for vertical value chain. And European and American authorities, they don't think it's a problem because they don't look at this established, cooperation within digitalization of commodity trade. They say it's good, it's promoting innovation, whatever. It's like, all those arguments for big tech, for abstinence in interference in the big tech business. They're saying it's very good, but maybe other, opinion is possible. Maybe, you look at this and say it's a kind of cartelization through digital platform. Maybe it's a form of, basically entrenching market power through this digital platform. And we don't hear this opinion much within like established mainstream. So maybe to have a different opinion is very important. Diversity is very important. We almost killed biodiversity. We shouldn't kill, diversity of thinking at least.
Just to make a few
go
words
ahead.
here, I have my doubts about the advantage of BRICS, but in a macro view, not in a competition matter, because we are doing what we can do. But in a macro view, after 10 years, we are trying to get a new development bank being operating. So it's not operating still, but it will. So that's our first project together. But I'm not that skeptic, because I think if we join some micro and macro views, we can have something. So if I would be leading this process, the broader process, I would be fostering investment in each country. I would be opening the trade among the countries. So if you put the countries closer in a macro view, maybe you can maybe have a competition policy agenda more that you can hold in a better situation, because right now I think it's just a project and it's just we do some cooperation in some areas, but in a broad agenda we just have the new development bank being done. So that's my
Thank you. Shannon, do you want to say something? Well, I think we've unfortunately run out of time. I want to thank this really distinguished group of speakers to take the time to travel this far to join us. Thank you very much for a great panel.